My name is Michael Geer, President of the Pennsylvania Family Institute. We thank you for joining us for this Live at Lunch webinar. And for those of you who are unfamiliar with the Pennsylvania Family Institute, maybe you heard about this through Facebook or somebody else told you about this webinar, you can find out more about us at our website at pafamily.org. And the Independence Law Center will be sharing their resources at the end, but independencelaw.org, independencelaw.org can get you to their website, which will tell you about the cases that they engage in on the issues of religious liberty, sanctity of life, marriage, and family. And they do all of the work for the Independence Law Center for their clients on a pro bono basis, thanks to the support that we receive from folks like you across the Commonwealth of Pennsylvania and foundations that support that work. Well, with that, I'm going to now go live. And hopefully you will be seeing me there on the screen. Again, my name is Michael Geer, President of the Pennsylvania Family Institute. I want to welcome you to this Live at Lunch webinar focused on a Supreme Court ruling that came down this week, actually on Monday of this week, a case, the main case that's called Bostock versus Clinton County, Georgia. A couple of other cases were tied into it as well, including the Harris Funeral Home case, as it is described, one that we at the Pennsylvania Family Council and Pennsylvania Family Institute, and especially the Independence Law Center, are familiar with because of an amicus brief that was submitted in that case. And the case, ultimately, these cases dealt with the Civil Rights Act of 1964 and Title VII specifically in that employment issues related to that, or in the Civil Rights Act, dealing specifically with the definition of sex and the inclusion of the word sex and sex discrimination in that. And the question before the court in a simplified form, and we'll hear from our attorney, Chief Counsel Randall Wenger, in just a moment about it, but the question kind of before the court is, does that sex discrimination inclusion in the Civil Rights Act also cover sexual orientation and gender identity? That's been an issue that's been debated for a long time in the Congress and in state legislatures, like right here in the Commonwealth of Pennsylvania, and even in local realms. And for about 30 years, that issue has been discussed in the legislatures, and courts for about 30 years have said, no, it's not included. And now the Supreme Court has come down with a decision, a majority decision in a 6-3 decision, authored by Justice Neil Gorsuch, that has come to a different conclusion than those courts have done for the past 30 years. So let me welcome our Chief Counsel, Randall Wenger from the Independence Law Center. Randall, it's good to have you with us. So give us some background on these cases, if you would.
Sure. There are three cases that were consolidated as one for oral arguments. Bostock versus Clayton County, Georgia, Altitude Express versus Zarda, and Harris Funeral Homes versus the EEOC. Two of those cases dealt with the question of whether there were protections under Title VII of the Civil Rights Act. So employment law protections on the basis of sexual orientation. One of them had to do with whether there are protections on the basis of gender identity. And just to give a little bit of background, because so often we talk about these cases from a very top line abstract sense, and it's useful to dive in just a little bit to the facts sometimes so you can get a feel for what might have been motivating an employer in a situation like this. So Harris Funeral Homes was a family business for many generations, a funeral home. And so they put a lot of effort into trying to make families feel comfortable, to not draw any attention to themselves as the funeral home, but put it completely on the deceased and on their family. And so part of what they did is to have a very conservative dress code. Men wear dark suits, women wear dresses, and they hired someone, Stevens, to help as a funeral home director, hired as a male, but then 6 years after starting employment, told the employer that I am I'm now planning to come back and identify as a female, and I'm planning to wear dresses to work. And the owner of the funeral home company talked about the dress code issue and how important the dress code was, but they couldn't reach any agreement on that, and so they ended up parting ways. And it's because the funeral home owner didn't want to really create a distraction from those who were suffering at a time like that. So that case then ended up winding its way through the EEOC, the Equal Employment Opportunity Commission, through the federal court, and then all the way up to the Supreme Court, and then consolidated with those two other cases. And so then the question before the Supreme Court was, what do we do with this? Title VII has 5 categories of protection: race, religion, national origin, sex, our sexual orientation and gender identity included in there, even though they're not written, even though those terms aren't written there. And the Supreme Court, 6-3, with a decision written by Justice Gorsuch, stated, yes, the sex protection is also a protection on the basis of sexual orientation and gender identity, because according to Gorsuch, anytime that somebody is making a decision on the basis of sexual orientation or gender identity, they're also making a decision on the basis of sex.
Now, with that decision, that has sweeping implications. I mean, not just for the Harris Funeral Home and the other people involved in this, but very significant implications, right?
Well, it certainly does. And there are problems whenever the court system legislates from the bench. And one of the reasons why there are problems, quite apart from issues of separation of powers, is that the courts will make some kind of pronouncement, but not deal with the details. And these are issues that get really, really complicated. There's a lot that you need to deal with when you add new protections into a law, and trying to determine what are those kinds of things that we're going to treat as invidious, as hateful, because it's not as if every time we make distinctions for given reasons do we consider it invidious. There are times when we look at sex discrimination and say, yeah, this really isn't a hateful form of discrimination. This is a distinction that's made based on the real biological differences, things that really actually do matter. And so you can make decisions on that basis, like what is the sex of the janitor that you're going to hire to clean the women's locker rooms and bathrooms in a skyscraper. We're going to hire a female and a male, one of each. We're going to make a sex-based choice so that we're respecting the bodily privacy of the users. And so our law has understood that not every time do you make a distinction is it invidious discrimination, but when the courts are basically making law, they're not dealing with all of those questions that are left unanswered. And so these are issues that have been debated both in Congress and in our state legislature in Pennsylvania for years. And the laws have never actually passed, either in Congress or in Pennsylvania. To a large extent, it's because of how complicated the issues are. Whenever I've gone in and talked to legislators, I've talked with them about how we all want to make sure that everyone is treated with decency and respect. But there's so much that ends up going along with this that people don't catch at first blush. But here, when you have the court doing it, there's even less provision and understanding being made for the issue. And it's going to end up in a lot of litigation as we try to figure out, so what does this mean for a Christian school who wants to hire persons who share that school's beliefs about what human sexuality and in marriage and gender mean. What is this going to mean for bathroom privacy? What is this going to mean for girls' sports? What is this going to mean for women's shelters? What is this going to mean for wedding service providers? What is this going to mean for Catholic social services with adoption and foster care? And the list goes on and on and on. When you do this from the courts, you end up with a whole lot more questions than you get answers.
So we're going to get into some of those implications, and there are folks on the call, as I've looked in the chat box. If you have not yet put in the chat box, if you're a part of this webinar and want to let us know where you're signing in from, we'd love to hear that, or what you do. I see some lawmakers that have signed in on this, and representatives of Christian schools and others that have to deal with the implications of this. When a Supreme Court ruling comes down, especially one as momentous as this and challenging as this, it does have significant implications, which is why we're doing this webinar and why we have our Chief Counsel, Randall Wenger, here on the call. And I want to correct something I said at the top as I was kind of winging it there in the introduction. I said 30 years of judges dealing with this. No, 30 lower courts have looked at this 1964 decision and whether or not sex includes sexual orientation and gender identity. And 30
actually, I'll correct you once again. It was 10 courts with 3 judge panels. So 30 judges, that have looked at this and unanimously came to a different conclusion.
Thank you very much. See, so I'm glad we had that time to correct, because I looked at my notes here and I say 30 judges, and you understand the 3-judge panel thing, and me being an amateur player in the legal realm here. That's why we have you, the expert, and me, the I don't know what you call me after those 2 flubs. In any event, happy to correct the record on that, because I want to have it straight for those who are listening, because we want to give the facts here. So before we get in, more deeply into these implications, I mean, implications just related to the court. I mean, we've seen this pattern of, you and I are very familiar with the Roe versus Wade decision. I mean, that was judicial fiat. That was a result that the court seemed to want in terms of forcing abortion, legalization of abortion, imposition of abortion throughout all 9 months of pregnancy on every state in the union.
When that could not be done through the legitimate legislative process.
Right, and so that was judicial activism, to say the least. We've been working for years to try to get good justices on the Supreme Court and to try to change that kind of thing, and things have gotten better in some cases, but we see this, even, Justice Alito calling this, legislation, and saying that, just decrying it, and Justice Kavanaugh, saying no way possibly that the Constitution or the common sense reading of the word sex in that 1964 law creates this result. So, I presume you as an attorney are dismayed when you see courts acting in a way that would more likely be described as what the legislature would do.
Well, it is, and you can. The dissents are really fascinating. So for anyone who wants to delve into legal reading, take a look at these decisions. They're readable. They can be difficult just because your head wants to explode sometimes when you're trying to follow the logic that you disagree with. But it's fascinating and interesting, and gives a good history in terms of what's going on. But as Justice Alito and Kavanaugh pointed out clearly, courts aren't supposed to come up with over literal reading of laws. Over literal in the sense that it then ends up straying from the plain meaning, from the plain understanding of what the people thought they were voting on. And so laws can end up meaning a whole lot more than what the original drafters were intending, but they shouldn't go further than what the laws actually mean. And I'll give an example by that. Title VII was meant, the sex provision in Title VII was basically to prevent discrimination against women in the employment context. but you look at the terms, and it's fairly clear that the terms can go both directions. It can help men who may be discriminated against as well as women being discriminated against. And anyone who voted on that law, if you had asked them, what does this law mean? They probably would have been talking about protecting women. And then if you said, well, would it protect men too? And like, yeah, of course it would. They may not have thought of that as the original purpose, but yeah, it would have protected men too. Or one of the examples that the justices talk about through the opinion is there was a certain employer who would not hire women single moms with young children, but would hire single men with young children. And so the folks in Congress may not have thought about that particular example, but it's very clear that, yeah, discrimination on the basis of sex, yeah, it's discriminatory if you treat women in hiring different than you do men, in terms of whether they have young children. So, but what's going on here is nobody would have thought that they were adding protections on the basis of sexual orientation or gender identity. That would have been furthest from their thoughts, and it would have made their heads spin to try to follow the logic of why that would be. That's what's wrong with the decision today, this week. The textual reading is such an over literal textual reading that nobody would have thought that is what they were voting on.
Now, this decision was 6-3. Justice Gorsuch writing the opinion, but also Chief Justice Roberts joining in on this decision. And just real briefly, a lot of people thought it was likely to be a 5-4 decision, could go one way or the other. If Justice Gorsuch had gone the way of the conservatives of Alito and Thomas and Kavanaugh, still might have been a 5-4 decision. I mean, is it
right?
I know you can't read the tea leaves or make predictions or anything else, but it's kind of one of those 6-3. Whether Kavanaugh ruled this way or not, looks like a loss was going to happen anyway.
Well, yeah, and so I don't know what was going on at the Supreme Court when this decision was made, but there are all kinds of other explanations for this. What was going on behind the scenes? What might have been traded? What was Gorsuch possibly doing, saying, okay, I know this decision is going to go the wrong way. If I offer to join in this decision, I may write it differently. And so a 6-3 decision, but a 6-3 decision that gives at least some roadmap to win some of these issues like bathroom privacy and women's sports and religious liberty issues. So this was a bad result, but it could have been a far worse decision that could have almost guaranteed a loss when it came to bathroom privacy, women's sports, and other issues. The way that it was decided, I feel like actually gives some roadmap for victory. So for those of you who are listening and feeling like, oh, all is lost, and how are we ever going to win these issues that are so important to us in terms of the religious liberty issues for schools or bathroom privacy or girls' sports, there are ways to win these things that this decision helps us out with in ways that I wasn't expecting when I first read a 6-3 decision, started reading through the opinion and thought, okay, there are a few things in here that we can actually use. We may be able to make some lemonade out of these lemons.
So it's interesting when you talk about, again, we don't know what happened behind the scenes, and it'll be maybe something that historians will note, or maybe Neil Gorsuch will write in his memoirs after he's off the court. But it reminds me a little bit of having dealt with the legislative process. And again, this sort of makes the court feel like a legislature. There are times when legislation is moving through the General Assembly, and it's not great legislation, and you have some lawmakers who oppose it, but they think, well, it's going to pass anyway because the numbers are there. So I'm going to engage in it and try to make it as good as it possibly could be, knowing that it's going to pass. And if I don't engage, it's going to be worse otherwise. I don't know if that is what happened there, but I've seen that kind of syndrome, and you look at it and you say, okay, well, maybe that's what happened here. I don't know. So we're going to get into the implications now and where we go from here, because I know that's why nobody just wanted to come in here at gripe session and us complain about the Supreme Court, because you can just go on Facebook and find that. We want to provide some answers, some hope, and some direction for folks in a challenging circumstance. So that's what we're here. That's why the Independence Law Center exists, to fight for what is right, to take a stand for truth. Those of you who have signed in, I hope that's why you're here, and that's what we hope to provide. If you have questions that you want to ask, there's the Q&A box down there at the bottom, or the button that you can push and write your questions there. We'll be looking at those. Emily Krebs from our team here at the Pennsylvania Family Institute, who works very closely with the attorneys on the team, will be helping to answer some of those questions in writing if we can, and then we'll be tossing those to Randall Wenger a little bit later in the webcast as well. So with that, Randall, let's jump right into it. So there are obvious implications to this. So let's talk about kind of some of the obvious ones. So we have wedding service providers. We have people who do wedding photography or own venues where they host weddings or things, and may decide that because of religious convictions, they don't want to participate in hosting an event that violates their Christian faith, their conscience. What does this decision mean for them in your estimation? Again, we don't know with any certainty about any of it.
Yeah, that's probably the area that gives me the most pause. That's where I'm most sobered by Monday's decision, because the logic of the opinion was, anytime that you're making a decision on the basis of sexual orientation, you're making a decision on the basis of sex. So that could just as easily be then applied to public accommodations as it was to employment. So for the wedding venue, for the wedding photographer. Now, those issues with the wedding service providers, those are typically dealt with by state law, not by federal law. But immediately following this decision, there was a statement made by someone on the Pennsylvania Human Relations Commission, who oversees the application of our state law, saying, yeah, there's no principled reason why you would apply this differently to housing or public accommodation than you would in the employment context. So there's no doubt going to be litigation on this issue. And then the question is going to be, to what extent do principles of religious liberty then protect the venue owner or the cake baker or the florist or the photographer? And that's going to be an issue that needs to be decided. And we already know that there are cases like that are before the United States Supreme Court.
Right. I mean, Baronelle Stutzman, who many of our friends here in Pennsylvania have met at our banquet, she was there a couple of years ago, and her case out of Washington State related to her facing basically a loss of everything because of her choice not to provide flowers for a same-sex wedding ceremony for clients that she had served for years.
Yeah.
Where do you see that going?
Well, her case went up previously, and then when the Jack Phillips case, the Masterpiece Cake Shop case, was decided in favor of Jack Phillips, the Supreme Court remanded her case, vacated the decision, remanded her case back down to the Washington State Supreme Court for Washington State to take another look at it. Unfortunately, they unanimously still said that she lost, sent it back up to the Supreme Court, and the Supreme Court is sitting on that case, presumably because there is another one dealing with Catholic social services, and whether they need to place children with same-sex couples. So there was litigation that arose in the city of Philadelphia. The city of Philadelphia said, we're not going to allow you to do foster or adoption care placements in our city anymore because you won't place children with same-sex couples. For that matter, they won't place children with any unmarried couple. And according to Catholic Church teaching, marriage is between a man and a woman. So they were being asked to do something that violated their faith. The Supreme Court is taking that case. And the case is being briefed right now. We filed a friend of the court brief. And so Baronel Stutzman's case is being held, presumably pending the outcome of this other one that deals squarely with the tension between LGBT rights and religious liberties, and how those two can be reconciled in a way that hopefully respects everyone.
So that's one area where litigation is likely to continue, et cetera.
Yes.
You talked about public accommodation and housing kind of things and implications with this, and we're going to talk legislatively about that in a minute. But a famous case out of Alaska involved a homeless shelter for women where a transgender, a man who claimed to be a woman demanded entry there. And because the shelter dealt with women who had been subject to abuse and sexual abuse, et cetera, they denied entry, not to go into detail about that. But when you think about a homeless shelter or those places that serve, especially women in those kinds of very vulnerable situations, and the fact that there were those who were trying to force and took this homeless shelter in Alaska to court to say they have to admit a man who says he's a woman, does this case have implications with that?
It does have implications. Justice Gorsuch was very clear that he wasn't answering anything beyond the employment context under Title VII, but the logic of his decision, I think, it does help out the women's shelters. He did not say, as many were advocating for, that gender identity and sexual orientation are forms of sex, and that's why they should be protected on the basis of sex. Justice Gorsuch didn't go there. He reasoned the entire decision on the basis that sex is the biological distinctions that we've historically understood, the biological distinctions between the two halves of humanity. That was the basis of the decision, and so I think those cases can be winnable, because to just say, well, it's sex discrimination then to not allow me, a man, to go into a women's shelter is really nothing new. That's all that they get from the logic of the Bostock decision. And women's shelters actually do discriminate on the basis of sex. They've always discriminated on the basis of sex. But we've determined that that's okay, that that's not an invidious form of discrimination, because we have those places separated because of the unique problems that women have faced that have caused them to be at a shelter in the first place. And so that's not been deemed to be an invidious form of discrimination. So it's not that you can have separate places like a women's shelter because sex is a protected class. It's actually quite in spite of the fact that sex is a protected class, but because of the important interests that there are in separate spaces. So I think this decision actually helps out the women's shelter. It gives a path forward for the women's shelter in the same way that it gives a path forward for bathroom, locker room, shower, bodily privacy issues.
I wanted to ask you about that, because that's something that communities across Pennsylvania, across America, are grappling with. School districts and school boards, and there are numerous cases that you have been involved in, and the Independence Law Center has been advising on those things. So, what's the prognostication on that?
I think those cases are in a much better spot than they were before this decision, ironically, because the cases that have gone the wrong way have been going the wrong way because they've been conflating sex and gender identity, and basically saying, look, a boy who identifies as a girl really is a girl, and so you're discriminating vis-a-vis the other girls. the logic of that gets lost by this decision. Here it's just it gets back to the whole sex discrimination question. If a boy who's identifying as a girl can't get into a girl's locker room because he's biologically a boy, that's sex discrimination based on the logic of this decision. But it's always been sex discrimination. And regardless of the fact that it's sex discrimination, our laws have always allowed there to be those separate spaces, in spite of the fact that it's sex discrimination, because of the importance of protecting bodily privacy in those settings. So that doesn't change. What happened in this decision doesn't give additional fuel. In some ways, it sort of sucks out the oxygen from the air. Now, you know, I've been watching cases for enough years to know you look at a decision, and based on the logic of the decision, you should be fine. But then things keep progressing down the pike and get to a bad spot. So I'm not saying this as a prophet to say I can guarantee you we ultimately win this at the end of the day. But what I can tell you as a practitioner in this area, it's going to be a lot easier to argue those cases. The same thing for women's sports, to argue those cases today than it was last week.
Yeah, no, that was the next question I had related to girls' sports in high schools or other settings. We see the situations in Connecticut, you know, where most of the track and field records are now held by boys who identify as girls, because they, in that state of Connecticut, have allowed boys who identify as girls to run races against girls, and there's a lawsuit filed related to that. The Trump administration has come out with guidance related to this that goes opposite in many respects to this Supreme Court decision, or at least people's thought of the implications of this Supreme Court decision. So that's still an area of activity or an area where it's not clear at all how it's going to play out.
It's not clear how it's going to play out, but again, there is the ability to make some really good arguments, to just say, look, there's nothing new here. What the Supreme Court is saying is, yeah, this is discrimination on the basis of sex, but we've always known that it's discrimination on the basis of sex. We've not considered it to be invidious discrimination, which is why under Title IX, which is federal education law protections in the basis of sex, while the regulations there have always said you can have these distinctions on the basis of sex, even though the law is supposed to eliminate sex discrimination, we don't consider separate bathrooms and locker rooms and shower facilities to be sex discrimination. And we don't consider separate teams for men and women to be sex discrimination, because it's not invidious discrimination. It serves an important purpose to really create opportunities for women.
We're speaking here on the Pennsylvania Family Institute live at lunch webinar with Randall Wenger, who's the chief counsel of the Independence Law Center and has litigated on some of these issues and written amicus briefs, including on the Harris funeral home case. We'll talk a little bit about that in a few moments, and also get to your questions. You can, if you have questions, can put them in the Q&A box there. We'll be getting to those shortly. And as well, we plan to have this recorded and available for later for those others who would want to see this content. We'll make it available on the Pennsylvania Family Institute website. There are folks here on the call that are asking questions and representing religious schools, religious ministries, employers, who are now wondering, okay, so as a Christian school or as a Christian ministry, we make distinctions on who we hire based on, those that fit a biblical model on human sexuality. So Christian school is not interested in having a teacher or someone in their employ who lives a lifestyle that is in violation of clear scripture. What happens here?
What happens here? Boy, does that mean that I get to sit on the Supreme Court and then I could tell you what happens here? But so Justice Gorsuch and in the majority, they basically said, hey, there are other cases that are going to come, and then outlined some of those cases that they'll have to hear and decide. And this would be among those cases. But so Justice Gorsuch did say very clearly that religious liberty is critical, and it's critical for a society like ours that's pluralistic. We need religious liberty in order to protect those differences that we have. Religious liberty is one of those escape valves that makes culture work. We need the ability to be able to follow our faith. If we don't, everything kind of breaks to pieces, and none of our other liberties get protected if we need to violate our most deeply held convictions. So the court didn't answer the question. The court said, yeah, we're just going to have to wait to look at this at another day. But they did take some time to talk about the religious liberty protections that would apply, including under Title VII itself, under the employment law that was at issue, where religious groups can make hiring decisions on the basis of religion. Now, the problem has always been, what does it mean to make hiring decisions on the basis of religion? So Fontbonne Academy is a case that I bring up often, where Fontbonne Academy up in Massachusetts, they hired somebody. Turned out the person that they hired was gay. During the hiring process, the nun who was the headmaster of the school said, we're looking for model Catholics. We want you to consider yourself a minister of the faith, because kids are looking to you as an example of what our faith means. And so they made the hiring decision then to say, look, we made a mistake here because you're living a life that's not consistent with church teaching. So the employee sued the school, and the judge said, yes, you can make decisions on the basis of religion, but you can't make decisions on the basis of sexual orientation. And so at least this Massachusetts judge said, hey, you've got religious protections, but it's not going to help you here. Federal law, I think, would give some additional protections to be able to envision the entire question differently. And I feel like that's what Gorsuch was hinting at in the opinion when he was talking about the religious protections. He obviously was assuming that it would give some kind of protection in a context like this. And so I'm still bullish on religious liberty issues, and I'm still particularly bullish for Christian schools, because it just really doesn't work if you've got the heavy hand of government saying, we can tell you who you need to hire, even if the people who are working for you don't share your mission. Because in situations like that, what does the employer want? The employer wants the exact same thing that every employer wants. They just want to hire people who share their mission. It just like the Sierra Club is going to want to hire people who share a commitment to environmentalism, and animal rights groups are going to want to hire people who share commitment to those goals. The same is true for Christian schools. They want to hire people who share the religious mission of the school. And I think that that desire, that logical desire on the part of schools, I'm still bullish on that one.
Well, in the same way, lawmakers, whether in Washington or Harrisburg or in state capitals around the country, want to hire people on their staffs who share their mission and their goals, et cetera. And the Trump administration, or if there's a future Biden administration or others, want to have people on the inside working for them that match their values, their conscience, and everything else. It just makes simple sense. So I mentioned lawmakers there because there are those who are talking about, okay, now, and they're lawmakers, some who have been advocating for sexual orientation and gender identity laws, anti-discrimination laws as they would describe them, for some time now. We've been challenging those and with the help of folks across Pennsylvania, making our voice known about the implications and how dangerous it is to rights of conscience and to religious liberty and freedom generally. The advocates of those laws and those proposals in Pennsylvania have said the problem in Pennsylvania is that you can, if you're gay, if you're homosexual, you get married on Saturday to your same-sex partner, that you can be fired on Monday as a result, and saying that that's a problem in Pennsylvania, that people are being fired because they're gay. Presumably, there was not evidence that that was taking place in Pennsylvania anyway, that had not been presented by those who testified about that. But then those would say, well, this ruling by Justice Gorsuch in the 6-3 ruling eliminates that argument. And yet there are those who are saying we need more laws in Pennsylvania. How do you respond to that? And what should lawmakers be looking to do here in our state? And what should citizens be paying attention to?
Yeah, I would say that what happened on Monday actually takes some of the wind from out of the sails of those who have been advocating for passing a sexual orientation, gender identity law here in Pennsylvania, because their biggest talking point was in the employment context. And at this point, it's clear that at least according to the interpretation of federal law at this point, and the same is true with the Pennsylvania Human Relations Commission's interpretation of Pennsylvania law in the employment context. So there isn't that can't be the reason for passing a state law. And it's really the other stuff that ends up getting so extremely tricky, the interplay then between religious liberty issues for, again, the Christian schools. What does this mean for creative professionals? And I'll give a quick example. Blaine Adamson, a t-shirt printer in Lexington, Kentucky, was asked to print a t-shirt for a gay pride event. He didn't feel like he could do that in good conscience, directed them to somewhere else that would do a good job for them and do it at the same price. They ended up having it done for free, which is a pretty good price. But he felt like he couldn't do it. And there were plenty of other things, even religious things, that he didn't print because he didn't feel comfortable doing it. There was a church youth group that wanted Jesus in a bucket of Kentucky Fried Chicken. He felt like that was sacrilegious, couldn't do it. So he was then prosecuted under Lexington, Kentucky's Human Relations Act. And during the time of the litigation, there was a lesbian print shop in New Jersey that actually came to his defense and said, quite logically, that this is really, on top of everything else, a freedom of speech issue, where we should be free not to speak. He should be free not to speak messages he disagrees with, to protect that print shop owner's ability not to speak messages that she disagreed with. That's the American pluralism at its best, where we recognize, and it's easy for us to recognize in the speech context, freedom of speech for somebody that I disagree with is freedom of speech for me. It cuts both directions, and that's something that should be protected. We over the last 10 years or so have been having a harder time seeing that same principle when it comes to the free exercise of religion, but that principle still exists. If we're going to have a free pluralistic society, everybody needs to be protected in their ability to follow their most deeply held convictions. Otherwise, there's no protecting our freedom to be who we are and to live according to our own conscience. So we need to be careful in these laws where folks will say, look, we need to pass them to show dignity and respect for everyone. And my argument has been, we do want to show dignity and respect to everyone. And that's precisely why we shouldn't be passing these laws, because in passing them, we're treating good people as lawbreakers and setting up these statutory provisions that run roughshod over constitutional principles that are meant to help us all, regardless of what our religion is and where we stand on these issues of public significance. And I often point out in these contexts too that Justice Kennedy, even in the same-sex marriage decision, pointed out that there were reasonable people of goodwill on both sides of the marriage debate. These reasonable people of goodwill shouldn't then be punished by state or federal non-discrimination laws just because they believe that a marriage is between a man and a woman and don't want to don't want to participate in a same-sex wedding. So I think oftentimes the heart behind people's positions gets lost in these debates, and there are folks that want to take the moral high ground and say, hey, we're the ones in favor of civility and love. And I would say, look, we're all talking about civility and love, but let's talk a little bit more, because the way that these laws play out certainly don't seem civil and loving.
So we want to talk about a path forward, because what we've described here, especially with the path forward, at least that Justice Gorsuch wrote in there, which is there's going to be future litigation. If I might say something a bit snarky towards attorneys and courts, is it seems to be the permanent job opportunity for attorneys to continue to appear before the court to defend hapless folks like us that just want to simply practice what we think the Constitution says we're allowed to practice. So that was enough of my statement there about attorneys and courts. But so the Independence Law Center obviously exists to help defend in these sorts of situations and to provide guidance to Christian ministries, to individuals and others who, as we said before, even prior to this ruling, there have been significant assists that we have provided to these ministries. We used to say that we need one of those deli or pizza shop, tickets so that you can get in line to get the assistance from these fine attorneys that we have at the Law Center. But there is guidance available for bylaws and other things that can help, as well as just how you describe positions on the employment issue. I think it becomes even more important now, doesn't it, Randy, about how you describe the different positions that you have in a school setting or a ministry setting.
Well, certainly. There's a lot of help that we can give you. We do our work free of charge, despite what Michael was saying earlier. This particular attorney and our attorneys are not in here for full employment. We do our work free of charge, and it's because of generosity to Pennsylvania Family Institute and the Independence Law Center that we get to do the work that we do. But contact us, because a lot of people have been. And so if you're on this call saying, I did try contacting you, but you haven't got back to me yet, I'm sorry, we're working on it. It's for obvious reasons been a very busy week, but there are things that we can do. There are things that we can do to advise. Yesterday, there was an attorney who called me up and said, what do we do? There's this other case, and it's dealing with bathroom privacy issues. How do you reconcile this then with the decision that came down? And I was able to talk through that and plan to provide some additional assistance. But with the wedding service providers too, there are things that can be done right now to give some level of protection. Don't contact us. Don't wait to contact us until you've got some kind of problem. Contact us beforehand, and we'll help talk through what your particular convictions are and what we may be able to do beforehand to help you. So we've been busy in these areas, trying to prepare for the future, and we're going to continue to be doing that. I mean, we have cases dealing with these issues to be litigated, and looking at taking other ones on, and friend of the court briefs, dealing with a whole slew of issues that come out of decisions like this, like pronoun use. Just this month, we filed a brief regarding pronoun use, and do people need to be forced to use a preferred pronoun, or do pronouns actually mean something? Is that then forced speech? So the issues really abound, but we are here to help you navigate these issues in a way that fits your conscience. So we stand ready to help. And
this provides an opportunity that I had not intended to take, or even thought about putting this webinar together, that we would do this, but our team at the Independence Law Center needs to grow. Our board of directors has said we need to help the attorneys that we have on the team with more attorneys. The expertise that they have that is in high demand. That joke I made about the tickets and get in line is, you know, they can be overwhelmed, and the challenges are going to continue. So those of you that have the capacity, and the Lord's blessed you with the ability to financially support the work of the Independence Law Center through the Pennsylvania Family Institute, those contributions are tax deductible, and you can make them online at pafamily.org/donate. Didn't intend to do that, but I just know as Randy is offering services for free, I know the burden that's on the team there, the work that they're doing, and the midnight oil that is being burnt on behalf of religious liberty, and the concerns that all of you have. So your support is certainly, and your prayers especially, are very much welcome. There's some other questions that we'll hit here briefly, and some of them we don't really have the answers to, I don't think yet. One is from a good friend who's been fighting for sensible sex education in Pennsylvania and to resist the Planned Parenthood type model, which we don't even want to discuss here. It's just tragic what kids are being exposed to in many school settings. What implications would you see on this, Randall, on sex education and what happens in the schools, or things like transgender education, or even in medical settings, forcing of medical professionals to administer drugs and hormone therapy to, let's say, a teenage girl who says she's now a boy?
Yeah, you've raised a whole lot at once, and the benefit of that is I can take the question out of that I want, rather than necessarily dealing with the hardest ones. But there are the pressures that are coming from government, and there's the pressures that are coming from private forces. And the ways that we deal with the ones from the government are different from the ones that we deal with elsewhere. In some sense, the issues dealing with doctors, for instance, being asked to participate in sex change issues, whether it's administering cross-sex hormones or puberty blockers for kids, or surgeries. So say you're a plastic surgeon and then you're being asked to participate in this kind of surgery, or you administer hormone treatment for other reasons, but are asking to do it then for pre-sex change operation. I feel like vis-a-vis the government, the decision that came down today, this week, can actually be helpful. The thing that concerns me more is the pressures that are coming from private business and from the public. I think those are the things that are going to make it harder for doctors and for other professionals trying to figure out how to navigate this. There are pressures coming on folks to just get on board with this because it's a civil rights issue. And I think it's becoming increasingly important for us to articulate how rather than a civil rights issue, unfortunately, when we're taking part in this, we become agents of human suffering rather than human flourishing. So the Pennsylvania Family Institute was involved in bringing some experts into Pennsylvania to talk about, in particular, issues related to children and what serves them, children who are questioning their gender identity, and how best to serve them. And unfortunately, a lot of things that are happening right now are, again, leading to human suffering, things that folks regret down the road, rather than human flourishing, where we're given the tools and the wherewithal to find our way through these issues.
It is tragic when you see the human suffering, and even in the Harris Funeral Home case, and the friend of the court brief that was drafted for that particular case addresses some of the challenges related to the whole transgender ideology and what comes with it as well. There's still more questions. Unfortunately, we can't get to all of them here. And one of the things that I want to talk to you about, Randall, is we talk about a path forward for those who have tuned in here. We've talked about a little bit about, you know, the reality that there is going to be future litigation, and that we at the Independence Law Center hopefully we'll be there and bulked up to handle what comes our way in Pennsylvania. And we want to be there to serve. The other part of it is we have the Supreme Court ruling that came down this week, but we've talked about the legislation that has been proposed in 2010 and in 2012, and then came almost to passage in 2016 and was pushed back and pushed back again and again because of the voice of the people, because of people who came to the Capitol and spoke out, because of people who called their state senator or their state representative and said, this is too much, and the implications on my ability to live freely or religious liberty. So you're still, anyway, what I was going to say is you're still, I mean, the need for engagement is greater now than ever. It's not, oh boy, we just got socked in the jaw, so I'm going to sit down or out for the count.
Right, that's exactly right. I don't want anybody who's listening today to lose hope. And sometimes you go out there and you read all of the statements from a bad decision, and you're just ready to slit your throat and be done with it. And that we can't afford to do that as a movement, because the opposite of this is actually true. When we engage, we end up winning things that nobody thinks there's any way for us to win. And we need to be engaged, because if we're not engaged, I guarantee you we will not win. But when we are engaged for the long haul, we experience losses and we experience wins, and that's nothing unusual. If you looked at the ACLU's trajectory to victory over the years, they had a lot of losses before they had wins. We have wins, we have losses. We need to remain engaged in the court, engaged in the legislature, and engaged in the public debate, because at the end of the day, people need to understand that there are other options that promote human flourishing, that we can love everyone, that we can have friends and family members who are lesbian, gay, and transgender, love them, and disagree in some respects. And so we need to find out ways in society where, as we always have on every other issue, we've figured out ways where we can work together in good ways, show love, but be able to hold on to principles. And as an example of that, you had mentioned Baronel Stutzman earlier, but I think her story is such a good one. She was friends for a long time with a gay man who went to her flower shop. She made all kinds of floral arrangements for him and with him, and with her gay and lesbian employees. And so when same-sex marriage came to Washington State, he asked her to do the flowers for his wedding. And her response was, "For you, Rob, I would love to do it, but because of my faith in Jesus Christ, I'm sorry that I can't." But then they talked over all kinds of other issues. They hugged, and he walked away. And to me, that's just a picture of what American pluralism should look like. We may disagree on very fundamental issues, but we can still show love and we can still show respect. Unfortunately, that story didn't stay that way, because eventually the Attorney General of Washington State heard about what was going on from a social media post, and then her case ended up getting litigated. But I feel like we can do better as Americans, and so there are ways that we can engage, we can show love, but we need to stay engaged, because if we don't stay engaged, there are a lot of good people who are going to end up suffering.
Well, let me share my screen here with contact information that people can have for you and the Independence Law Center. Hopefully everybody's seeing that. The Randall Wenger, our Chief Counsel at the Independence Law Center, his email address is there. And then the Independence Law Center website, independencelaw.org. And Alliance Defending Freedom, which argued the Harris Funeral Home case and is a strongly allied organization to us in our work at the Independence Law Center and the Pennsylvania Family Institute, is a great resource as well on these issues broadly as well as this specific one as well. Any other comments, Randall, that you will make before we close out? And I'll close in prayer. Any other comments? I want to thank you for your great leadership and for the wisdom that you and insights that you shared here today.
Well, I'm grateful for you all who were listening today. And again, if you have questions about your particular situation, do reach out to us. And you can just Google the Independence Law Center. If you don't remember the website there, get in touch with us, and we are happy to talk through these issues.
Okay. Well, join me in prayer, and we'll close and say goodbye. Heavenly Father, thank you, Lord, for this time. We thank you for the insights and wisdom that you have given to Randy and the team at the Independence Law Center, for the resources that come in that enable the pro-family, pro-religious liberty, pro-life work that it engages in. We do pray for our nation at this difficult time. I pray, Lord, that you would bring peace where there is division, and that you give wisdom to our leaders, from our president to our governor and to all those who are engaged in trying to make the world a better place. We pray, Lord, for the work of the Independence Law Center. We pray, Lord, especially for you to protect religious liberty, protect those who are under attack. We lift up Baronel Stutzman and others who are challenged because of their Christian faith here in this nation, and for all those who are persecuted around the world because they stand for you. We thank you, Lord, for this opportunity to be together, for the miracle of this electronic communications medium that we have been able to use during the season so effectively. And again, we ask, Lord, for your hand to be on us and on all those who join this call, and especially on our nation at this challenging time. In Jesus' name we pray. Amen. Thank you, everyone. God bless you.